morning, everyone. Welcome to the First District Court of Appeals. I think you'll see that Judge Bach is not able to be here this morning. She will, though, be watching our arguments, and she'll be participating in conference on the cases. All right, we have 3 cases set for argument today. The first case is case number C230059. This is Pamela Johnson White versus Thomas Edward Houston. And the attorneys that I have to argue today are Ms. Platzbecker for the appellant. Okay, good morning. And Mr. Zofchak for the appellee.
Good morning.
Good morning. And the second case that we have up for argument today is C220635, Treadway Gallery, Inc. versus A. Joe Baylor. I have Ms. Crossley Tate for the appellant.
That's correct.
Good morning. And for the appellee, I have Julian Peter Johnson.
That's correct, Your Honor. Good morning.
Good morning. And the final case for argument today is case number C220467, 230012, and 036. And for the appellant, I have Paul Crawshore.
Your Honor, Paul Crawshore, thank you.
Good morning. And I have for the appellee, George Musecamp.
Good morning, Your Honor. Thank you.
Good morning. All right, so we're going to start with the White versus Houston case. If the attorneys would please step forward. Ms. Platzbecker, would you like to reserve some time for rebuttal?
Yes, if I can reserve 2 minutes.
Just 2 minutes?
Yes.
Okay, I'll be keeping your time. You'll see the lights in the at your podium. When you have a minute left, the yellow light will come on, and the red light means you've used your initial time.
Okay, thank you. Are you waiting on me? Okay.
Whenever you're ready.
Sorry. Good morning. So this particular case, I think it's important to remember, was resolved at the summary judgment phase. This is important for 2 reasons. In order to have summary judgment, there must be no genuine issue of material fact, and all facts are to be construed in favor of the non-moving party. From the outset of the case, the parties were on uneven playing fields as to their knowledge of the facts. Ms. Johnson White had owned the property at 755 North Fred Shuttlesworth since 1989, and the appellant, Mr. Houston, had owned the property at 761 North Fred Shuttlesworth only since May of 2021, which was only 6 months before the property, before the complaint in the case was filed. That gave Ms. Johnson White firsthand knowledge and experience as to her actions over the previous 30-plus years of ownership of the property, while Mr. Houston's only means for ascertaining the facts to this case was through the discovery process.
Let me ask you, ma'am, wasn't the easement of record with the auditor of Hamilton County or recorder?
So there was some dispute at the trial level as to whether or not that was of record. There is a deed that does mention a grant of easement, but then Mr. Houston's position throughout this case was that Ms. Johnson White had abandoned that easement.
Okay, and if he was only there, 6 months, how would he know that she abandoned an easement?
So there were some factors that came into play, his observations of the property. The first one being that the vegetation between the Johnson White property and Houston's property had become largely overgrown, indicating that no one had traversed between the properties in the area of the easement for an extended period of time. There were a couple other factors as well. There's a Cincinnati code provision that states a driveway has to be paved. And Ms. Johnson White had argued it was a driveway easement, but at the same time, she had not maintained it as a driveway. There was some commentary or some discussion that it had previously been paved, but that paving had gone away over time. which also leads to the idea that it was abandoned. After the deterioration of the first paved driveway, she chose not to repave it.
Well, you're not arguing that simply not using the easement is enough to establish abandonment, are you?
No, you have to have non-use as well as intent to abandon. Intent to abandon is a material question, though, and it's proved by a variety of facts. And so these facts of the overgrown vegetation between the property, the lack of a paved driveway, and then she also installed her own driveway, all of those coupled together, we feel create enough of a material question that made summary judgment improper. Like I said at the beginning, we think it's particularly important that this was resolved at the summary judgment phase, where these facts were not fully developed. But again, at the summary judgment phase, there has to be no genuine issue of material fact. It's not, there has to be no genuine issue of material fact at the summary judgment phase. And then we're, again, construing all of these facts against Johnson White as she was the moving party.
So that's the only issue, right? Your client is not disputing that there was an easement. He's just saying it was abandoned.
Correct.
Okay.
So in her argument, Johnson White claims that Houston could not have proven that the easement was abandoned. She does this with blanket statements that between her or her deceased husband, they had continuously used the easement since 1989, and that she had no intent to abandon the easement. Again, these blanket statements don't dispute any of the facts. We go back to the fact that it was overgrown, there was no paved driveway, and she had installed her own driveway on her property.
So it has to be paved for what reason?
There's a Cincinnati code provision that says in order for a driveway to be a driveway, it has to be paved.
Okay. And you're saying she was using this as a driveway?
Yes.
Or this was was this like expressly written up as a driveway easement?
It was expressly written up as access from one property to the other. So, and then she claimed that she used it as a driveway. There's a garage at the back of her property, and she claimed that she couldn't access the garage at the back of her property without this driveway.
Okay.
So then when we focus on the three factors that point to abandonment, it also brings us to our second assignment of error, that Houston was blocked from conducting discovery and his Rule 56F motion was improperly denied. Johnson White owned the 775 property for the past 30 years, and Houston purchased the 761 property just 6 months before the complaint was filed. Houston's only mechanism for gathering facts as to building his defense was the discovery process.
Wasn't the problem here, though, that he didn't follow the requirements of Rule 56F by filing a separate motion and filing an affidavit attached to the motion? I mean, it seemed like this was denied more on technical grounds.
So as to your first question, it not being a separate identifiable motion, we would argue that the entire opposition to summary judgment was the 56F motion.
Is that sufficient under the law to do it that way?
So it was identified from the beginning that they were opposing summary judgment pursuant to Rule 56F, making it its own separate motion as opposition and summary judgment pursuant to Civil Rule 56F. The whole motion outlined the requirements as to how discovery was not conducted and as to what discovery was hopefully going to result in. So throughout the motion, there ultimately were all of the necessary factors.
Okay, but that didn't answer my question, pursuant to case law, is that a sufficient way of doing that in a response? Or it seems to me that most cases have held that it has to be a separate motion with a separate affidavit attached to that motion.
And that's where we think it does present as a separate motion. The opposition to summary judgment serves as the 56F motion, as
So you're saying it's opposition to summary judgment / motion?
correct.
Okay.
And then as to your question as to the affidavit, the case law criticizes other affidavits for different reasons. There's Kelly v. Ford Motor Credit Company, and they have a similar situation where there was an affidavit that was submitted by counsel rather than by the party. We believe that that case is distinguishable from the present situation because that affidavit was criticized for not having the necessary specificity as is required for an attached affidavit, compared to the affidavit by counsel in the present case included the specific reasons that discovery was not conducted, as well as the specific things that discovery would ultimately result in if it was conducted. Additionally, in Kelly v. Ford Motor Credit Company, it was also determined that the party requesting additional discovery already had that discovery in their possession. That's again distinguishable from this case because Houston did not have the discovery that they were requesting. Throughout the course of the underlying litigation, Houston had reached out to Johnson White's attorney to obtain dates for depositions so that Johnson White could be deposed, and she gave reasons that she would request depositions be scheduled for a later time. That gave Houston reasonable belief that she was going to cooperate in the discovery of depositions and there was no need to notice them. At the same time, that was later followed up with her summary judgment motion rather than Johnson White circling back to schedule depositions. Whether or not an easement has been abandoned is a genuine issue of material fact, meaning that summary judgment was inappropriate in this case. An intention to abandon is a material question, and it may be proved by an innumerable variety of facts, meaning no one case is sufficient authority for another. When we look at the three factors that we already had without any discovery, the overgrown vegetation, the lack of a paved driveway, and the fact that Johnson White had since put in her own driveway, we lead to a genuine issue of material fact as to whether or not she had abandoned the easement. Additionally, Johnson White strategically avoided discovery in this case because she knew that that would allow Houston to add some bulk to his abandonment defense. Houston's motion was identifiable as a 56F motion and was supported by the necessary affidavit that contains the necessary information. For these reasons, Houston requests that this court reverse the grant of summary judgment and reverse the denial of his 56F motion.
All right, thank you.
May it please the court. Matthew Zofchek on behalf of the appellee Pamela Johnson White, and with me in the gallery this morning is Mrs. Johnson White, just to let the court know. Through this appeal, Mr. Houston asked this court to upend well-established summary judgment standards in black letter real property law. Specifically, he asked this court to overturn the trial court's decision, even though he did not submit a proper 56F request, and despite the fact that he cannot point to a single genuine dispute of material fact in the record corroborated by any Rule 56 evidence. On the improper 56F request, the trial court got it exactly right. It was more than just a technical deficiency, Your Honor. It was both procedurally improper and substantively deficient. There was no separately identifiable motion filed. It was rather embedded in defendant's response to plaintiff's motion for summary judgment.
Well, appellant is saying that that's good enough.
That's not what was filed, Your Honor, and case law suggests otherwise. I would also state that there was no affidavit of the party submitted along with this purported 56F request. It was only after motions practice closed, over a week later, without leave of court, that Mr. Houston's counsel prepared an affidavit. And perhaps most importantly is the fact that Mr. Houston did not persuade the trial court why he did not conduct additional discovery sooner, or that the additional discovery he allegedly needed was likely to lead to uncovering genuine dispute of material fact, preventing summary judgment.
Well, I thought that your client was saying that she would cooperate with a deposition and then never did. I thought that was one of the issues.
Your Honor, we did have discussions with opposing counsel about the scheduling of depositions. I don't want to go outside of what's in the record. The fact of the matter is there's no genuine dispute of material fact here. All of those issues have been asked and answered by Mrs. Johnson-White under oath numerous times, whether that's through her verified complaint, her verified interrogatory responses, her multiple affidavits in support of her TRO motion, her motion for summary judgment.
So you're saying despite the fact that they weren't able to schedule a deposition with your client, it doesn't matter?
I'm not just saying that, Your Honor. The trial court said that twice in its summary judgment decision, as well as its motion for its denial of the motion for reconsideration, which is not an issue in this appeal. But if this panel looks to that decision, the trial court expressly says no additional discovery would have altered this outcome. That's what the trial court said. So, as this panel knows, 56F requests are reviewed for an abuse of discretion. This panel should affirm the decision below because it was not unreasonable, arbitrary, or unconscionable. And because the 56F was denied, the trial court proceeded properly to its summary judgment decision. And while that decision addressed multiple claims of the parties, appellant has conceded there's only one issue before this court, and that's Mr. Houston believes that there is a genuine issue of material fact regarding whether Mrs. Johnson-White had abandoned the easement. But there's no genuine dispute on that issue in the record, and certainly not any dispute corroborated by any Rule 56 evidence. Summary judgment decisions are reviewed de novo, and upon this panel's review, it should affirm the trial court's decision. Under Ohio law, abandonment of an easement requires two things that this court has already heard this morning: non-use and an intent to abandon. Mere non-use is insufficient. An intent to abandon is defined as unequivocal and decisive acts inconsistent with continued use. And the trial court summed this up very well in its summary judgment entry, where it said there is no evidence Mrs. Johnson-White ever intended to abandon the easement. Further, over the past 30 years, Mrs. Johnson-White and her late husband used the easement. Again, these conclusions have been supported through multiple representations under oath by Mrs. Johnson-White, verified complaint, interrogatory responses that were verified, multiple affidavits. How
do you address the overgrowth between the properties and the failure to pave the driveway?
In response, Your Honor, I would say grass naturally grows. We have nothing in the record about how tall this vegetation grew. Was it a couple inches, a couple feet? I don't know. It's not in the record, Your Honor. And as to the paving, whether Mr. Houston or prior owners paved their driveway, that's their concern. Mrs. Johnson-White did respond in a verified interrogatory response saying that there was a paved driveway on the Houston property when she first came into title to her property. Here's what's not in dispute on this appeal. The easement's valid. The easement is an express easement appurtenant. The easement has been of record in Hamilton County for over 60 years. Mr. Houston purchased the property while the easement was of record, and his own title policy reflects the existence of the easement. What Mr. Houston really wants is a court decision that erases the easement on the property he purchased. But that's not how the law works. Easements like the one we're talking about today are of record for a reason. And the purpose is to put people with an interest in real property on notice that an easement exists. To rule otherwise would upend black letter real property law. It would eradicate the sanctity and value of our public records, and real property law would devolve to a world of he said, she said, and that's unmanageable, and I don't think any of us want that. So for all these reasons, Mrs. Johnson-White asked this panel to affirm the trial court decision below in all respects, and I personally just want to thank this panel for the opportunity for oral argument. I know those are few and far between these days. This is my first appellate oral argument, my first time appearing before the First District. So
Well,
I'm
the
happy.
First District, if you ask, you get, so.
I will say I'm happy to answer any questions that the panel has. Thank you.
Thank you.
I don't have any for you. Thank you, sir.
Thank you. Ms. Platzberger, you actually have 3 minutes left.
I just have 2 points that I think it's important to reiterate. Again, this case was resolved at the summary judgment phase, and Mr. Houston brought up the defense of abandonment. The case law says that an intention to abandon is a material question that may be proved by an innumerable variety of facts, and this goes back to Mr. Houston was prevented from doing discovery. The statements of Ms. Johnson-White that her counsel refers to are blanket statements contained in her affidavit that say between my husband and I, we use the property we utilize the easement continuously since 1989. At no point does she reference any specific instance at which it was used, and at the same time, Houston has pointed to 3 specific factors that contribute to a conclusion that she abandoned the easement. Without additional discovery, Mr. Houston was prevented from fully developing his defense, but it makes summary judgment improper as there's a genuine issue of material fact as to whether or not she truly abandoned that easement. Ms. Johnson-White's counsel also references that a 56F denial is reviewed on an abuse of discretion standard, and while he is correct in that, there is the case Midland Funding LLC versus Farrell, which states the denial of a 56F continuance should be upheld if the party fails to show the requested discovery would have precluded summary judgment. Mr. Houston brought forth facts that would have overcome summary judgment if he would have been able to fully develop them throughout the discovery process.
And what were those facts again? Is it the grass and the driveway paving?
Yes, the overgrowth of the vegetation between the property, and I thank you for asking. I wanted to bring that up as well. You had asked as to the length of that Ms. Johnson's White's counsel referenced that there was no reference to the specific height of that grass, the extent of the overgrowth of that vegetation. Those are all things that would have come forth additionally in discovery. And therefore, for those reasons, Mr. Houston requests that this court overrule the summary judgment grant of the trial court and overrule the denial of the 56F motion.
All right, thank you. Thank you both for your arguments this morning. The case is now submitted, and we will issue a timely decision. Have a good rest of your morning. The next case up for argument is Treadway Gallery versus Baylor. And Ms. Crossley-Tate, would you like to reserve some time for rebuttal?
Yes, Your Honor, I'd like to reserve 5 minutes.
5? Okay, great. I'll keep your time.
May it please the court, Paige Crossley-Tate for Appellant Joe Baylor. This is fundamentally a case about the limitations on the scope of a trial court's authority when determining a motion for summary judgment. A motion for summary judgment must specifically delineate the bases or the basis for that motion under Civil Rule 56. And this applies to all cases in which a motion for summary judgment is brought. It is a burden that is placed on the movement. It's not placed on anybody else. The original motion for summary judgment must delineate with specificity what the basis for the motion is. In this matter, we had a trial court that just ventured beyond the very specific basis that was asserted in Treadway Gallery's motion for summary judgment and determined the motion on a basis that was not raised in the original motion.
What was the specific basis?
So, really briefly on the facts, Treadway Gallery is an auction house selling art and antiques here in Cincinnati. The appellant, Joe Baylor, is an individual who is interested in purchasing some art. She lives in Texas. So these auctions are conducted online. Certainly since COVID, I think they've been conducted online, maybe for longer than that. But she registered, Ms. Baylor registered, she participated in the auction. This was September 2019. And she won the auction. She won a painting by Palmer Hayden, who was a prominent American artist in the early mid-20th century. And she won the painting. She was sent an invoice by the Treadway Gallery. She did not pay that invoice within 30 days of receiving the invoice. That was the basis, that was the sole basis for Treadway's motion for summary judgment. In fact, it was all they asserted in their complaint. It is a defense to an action for breach of contract, certainly a defense to a motion for summary judgment for breach of contract, that based on non-payment, that her payment was not due. Ms. Baylor's payment for this painting was not due.
Because they subsequently altered the contractual terms.
That is correct. There was
Okay.
a text exchange between Ms. Baylor and Drew Treadway, who Don Treadway acknowledged as an agent for the Treadway Gallery. It said, paraphrasing very slightly here, okay, you don't have to pay for the Palmer Hayden painting right now. You don't have to pay for it until after we provide you a certificate of authenticity.
Well, she requested one, right?
That is correct, and this was acknowledged in, when we say certificate of authenticity, that certificate had to contain information of a certain kind, had to answer certain questions, not only as to is this a Palmer Hayden, but importantly, is this particular Palmer Hayden painting property of the U.S. government?
But wasn't she supposed to request or just any questions about authenticity of the paintings were required to be asked within 30 days, right? Wasn't that part of the original contract?
There are terms and conditions. We in opposing counsel have gone back and forth over whether the entire text of those terms and conditions were made part of the record in this action. But I have no reason to dispute that she was supposed to do that.
Okay.
Nevertheless, she had this conversation, she had this text exchange with Drew Baylor because there's this issue. And the issue is this Palmer Hayden painting. Palmer Hayden was a prominent American artist. He was hired by the federal government in the 1940s, 1950s, during the period where he was active, to produce works under the WPA. So there's an inventory of federal government property. This painting may be part of it, may not be part of it. It's not absolutely clear whether the federal government is going to assert an interest in this painting. But this was a concern that Ms. Baylor had in the circumstance. And she made that known. And both Don Treadway and Drew Treadway acknowledged during their deposition testimony that she had a concern about authenticity and provenance. But in any event,
Let me ask you, ma'am, is there still any dispute as to, I guess, whether there's the certificate of authentic is authentic? Is there still a dispute as to that?
there's a live dispute over whether this is WPA property or not.
Okay.
And we never got into it. It was not delineated as a specific basis. The Treadway Gallery never said, grant us summary judgment because we have fully satisfied a condition proceeding to payment.
But that's what the judge ended up finding.
She did, and in
Okay.
so doing, the trial court exceeded the basis asserted
Okay.
in the original motion. That's the problem. So we never had this opportunity to say, okay, so this certificate you've tendered, and I've referred to it as a tender rather than, performance. Number one, year after it was promised, and 9 months after the complaint was filed. This certificate of authenticity was promised in November of 2019, as I recall, and then suit was filed February 2020 with no certificate being tendered.
Okay, but they were, initially when they filed their complaint, they were disputing that the contract was altered to require them to provide the certificate, right?
That is correct.
Okay.
They did.
So then the judge found that the contract was in fact altered.
Yes.
And this certificate was required.
Yes.
And then they had filed for summary judgment, not on the basis that they provided the certificate, but on the basis that your client hadn't paid under
Within
the
30 days
contract.
of receiving an invoice. That is
But then the
correct.
certificate was tendered.
A year late.
And then the judge said, okay, now your client owes.
That's correct.
Okay.
And the position we're taking is court should have stopped a step earlier than that. When the motion for summary judgment simply said, we sent her an invoice, she should have paid it within 30 days, and she didn't. We said, her performance was not yet due. It is absolutely a defense to a breach of contract for non-payment that the payment was not due. And so we said we have a condition proceeding unsatisfied. That's a defense to breach of contract. That's it. So now we've eliminated one of the essential elements of breach of contract delineated specifically in the plaintiff's motion for summary judgment. And on that basis, the trial court, what we suggest is that the trial court should have just stopped and said, okay, on this record and on this motion, I have to deny the motion for summary judgment. Now what? Now what are we going to do? And then we would have had a meaningful opportunity to get into, does this certificate, was it timely? There's no time term
Right.
in it, right? So
It has to be reasonable.
that's right. So is it reasonable in the circumstance to do it a year later than it was promised? Is that reasonable? What's changed? Well, we never had an opportunity to talk about change in circumstances. It is the case, and I think I can say this because it is in the record, and that is in November 2019, when this text exchange took place, Ms. Baylor was in a hospital bed with some heart issues. So her circumstances, maybe they changed because of this health condition, I don't know, but in any event, we never had the opportunity to get into it. And we never had the opportunity to talk about the contents of that tender of performance in November 2020.
Okay, so there, like, for Judge Winkler's question, that's still an issue of whether the certificate of authenticity
Answers the question.
answers the
asked,
question of whether the painting's authentic.
Or whether it's WPA property.
Okay, so that's an issue, and then the idea of whether they timely produced the certificate
That is
to
correct.
require payment.
Yes, Your
Okay.
Honor. Yes, that's correct. So we have, the trial court going beyond the scope of the issues as framed, as specifically delineated in the movement's motion. I believe Judge Bach authored the Ackman decision, which and you were on the panel, Judge Winkler, I think you were also on that panel. So, that's our assignment of error number one.
Okay. And I was just going to ask you that I believe the record reflects that the certificate of authenticity was tendered right before the hearing on the motion for summary judgment. Is that fair to say? Or counsel said, yes, we've received a certificate of authenticity, but it sounds like you're still disputing, well, the issue of who actually owns the painting versus whether it's authentic or not. Is that?
Well, it's authenticity and provenance. This came out during the deposition testimony of both Don Treadway and Drew Treadway, but yes, you're correct. We're disputing whether the tender answers all the questions that Ms. Baylor had, and it were acknowledged during the depositions of both Don and Drew Treadway. And that is it a Palmer Hayden? Well, yes, apparently it is a Palmer Hayden. Is it, can you trace the provenance? How far back can you trace the provenance? Well, it turns out they can trace it back, and this was Exhibit C to Don Treadway's deposition, I think. They can trace it back to 2010 when it became part of the Parker collection. That's fantastic. That's great. What about all the way back to 1940, 1950 when it was painted? Did it escape the inventory of the U.S. government so that the U.S. government, whenever it gets around to it, can remove this painting from, presumably without compensation, to the present holder of the painting? Was there a marketable title to convey in this thing? That's kind of a big deal, and it's unusual. This sort of thing doesn't come up very often, I suppose. But the other matter is trial courts are confined to 56C competent evidence, and representations of counsel during oral argument are not evidence. They're not evidence. And
Wouldn't that be an admission? An admission by counsel?
well, they might be, but I'm still stuck with the fact that they went to a matter that was outside the scope of the matters as specifically delineated in the original motion. So you have the trial court, and I have some little experience with this. I would be curious and say, hey, tell me answer this question for me just because I'm curious. So James Birch was our trial counsel. He's one who argued this oral argument before the trial court. And so the judge had already determined that, yes, this is a condition precedent, and it wasn't satisfied even on the day the complaint was filed, so it's not a ripe or justiciable claim. That's just another matter. But just leaned forward and said, hey, how about the time term? Is there a time term in this? And Mr. Birch just responded to a direct question put to him by the court. Mr. Birch is aware that his representations are not 56C evidence. He's confident that the trial court is aware that his representations are not 56C evidence. But trial court absolutely, in resolving disputes, is going to be curious about the facts, going to want to have a full understanding of all the facts. So he simply answered the question. And he didn't volunteer it. He didn't expand on it after the trial court asked both of those questions that she put to him. He answered them directly, and he got back into the issues as framed in, his response to the motion for summary judgment. He didn't expand on it. He didn't say, court, yes, and you can determine this matter right now on what I'm telling you here in the courtroom. He never invited. He never induced. This was not invited error. And I'm just saying this because I'm anticipating that counsel will get up in a minute and talk about about invited error. Not invited error, he never asked the court to get into it.
And you are well over your initial time if you want to reserve some rebuttal.
Yes, ma'am.
Okay, thank you. Mr. Johnson?
Good morning, Your Honors. May it please the court, Julian Johnson for Treadway Gallery. At the outset, I would like to emphasize that the court need not agree with the trial court's reasoning to affirm its judgment. On appeal of the grant of summary judgment, the Court of Appeals applies the same test that the trial court did. If upon reviewing the record, the court determines that there is no genuine dispute of material fact and that Treadway is entitled to judgment as a matter of law, then the court may affirm the trial court's judgment without necessarily agreeing with the trial court's reasoning. With that said, I'll turn to the facts here. This is a straightforward breach of contract case. Ms. Baylor registered for an auction with Treadway. At the auction, she was the successful bidder on a $42,000 painting. Following the auction, Ms. Baylor challenged the authenticity of that painting, but Ms. Baylor's challenge to the painting's authenticity came more than 30 days after the auction and was untimely under Treadway's standard terms and conditions. Treadway ultimately offered to provide Ms. Baylor with a certificate of authenticity for the painting and delivered that certificate to her in November 2020. There are no materials in the record that suggest that this material was insufficient to satisfy Ms. Baylor's concerns as to the authenticity of the painting.
Do you agree that the contract was modified to require this tender of the certificate?
We maintain on appeal that the text message sent in November 2019, I think, was not an enforceable modification. It was a mere settlement negotiation.
But the court found this, right?
Right.
And you didn't cross appeal on that issue.
Right. There's case law that says it's not necessary to cross appeal to maintain that different reasons might support the appellate court's judgment.
Okay.
So
So you're
that
saying
our
we could
position is-
disregard that finding that the contract was modified?
Our position is that we maintain our original position at trial, but even if the trial court was right that the contract was modified, we still believe that that the judgment should be affirmed.
How is there not a genuine issue of material fact with regard to the timeliness of the tender of the certificate of authenticity?
I don't think there's really any question as to the timeliness of the tender of the certificate. I mean, the certificate was tendered after the complaint was filed, but there's case law, there's Rule 15 allows for, which the trial court relied on in its judgment, allows for amendments to the pleadings that relate back to the initial complaint based on the evidence that's revealed during discovery. And you don't even have to file a motion to amend the pleadings if the parties implicitly consent to resolving an issue on the matter, on a certain issue. And there's no cases that I'm aware of where a court held that Rule 15 cannot be applied as the trial court did here. The appellant has not cited the appellant's brief did not have any cases addressing Rule 15, which is essentially what the trial court relied on in its decision. I'm not sure, did that respond to your question?
Well, I mean, it's, it sounds to me like this case was just kind of this ever-evolving situation where your client files this complaint based on just simple failure to pay within 30 days. The defense was, no, we modified the contract to require this certificate. The judge agreed. And then the certificate was tendered during the litigation, actually after the motion for summary judgment was filed. So I question how that's not a genuine issue of material fact regarding the timeliness of the tender of the certificate. So it wasn't even litigated by the parties even.
Well, I'm not sure there's been any assignment of error on appeal stating that the timeliness of the tender is a dispute of fact. That's not my understanding of of what they're arguing is the dispute of facts.
What's your understanding?
My understanding is their question is how much time after the tender did they have to pay for the painting? You know, the painting's tender, the certificate is tendered in November 22nd, November 19th, 2020. The question is how much time after that date does she have to pay? Is her payment due immediately upon?
Because the judge found it was due immediately
Right.
upon tender.
That was my understanding of the genuine dispute that they were pointing to. Not so much did we, breach the contract by not tendering it,
Right.
within a shorter time period after she raises the first challenge to the authenticity. I mean, maybe I missed something in the brief, but my understanding is that wasn't the genuine dispute that the appellant is pointing to. Okay. Turning to the first assignment of error, Ms. Baylor argues that Treadway failed to address the import of the timing of the delivery of the certificate in its summary judgment briefing. To the contrary, this issue was discussed at length in Treadway's summary judgment briefing. Treadway repeatedly asserted that the timing of the tender of the certificate was immaterial because Ms. Baylor waived her challenge to the authenticity of the painting. Therefore, Treadway had no obligation whatsoever to deliver the certificate to Ms. Baylor. Ms. Baylor, on the other hand, asserted that Treadway had an obligation to tender the certificate as a condition precedent to her payment. The trial court actually agreed with Ms. Baylor on this point, but concluded that Treadway was entitled to relief in any case. In essence, what happened here is Treadway presented its position, Ms. Baylor was given an opportunity to respond, and the trial court found that Ms. Baylor's response had some merits, but ours did too. Ms. Baylor doesn't think that a court can do that, can't agree with one party on some things and agree with the other party on others. Rule 56 doesn't say anything to that effect, and we are aware of no cases where a court interpreted Rule 56 to prohibit a court from doing what the trial court did here. Agree with Ms. Baylor as to the condition precedent thing, but also agree with us that she was still in breach because we performed by providing the certificate to her. If the court doesn't have any further questions on the first assignment of error, I'll turn to the second. Ms. Baylor insisted the trial court relied on materials outside of the record in granting Treadway's motion for summary judgment, namely the terms and conditions for the sale of the painting. This argument fails for two reasons. First, Ms. Baylor admitted to the terms and conditions outlined in Treadway's complaint in paragraph 11 of her answers. In paragraph 11 of her answer, Treadway's complaint outlined the terms and conditions of the agreement. In paragraph 11, she admits that she agreed to abide by those terms and conditions. Additionally, the terms and conditions are in the record by way of Ms. Baylor's failure to timely answer or object to Treadway Gallery's request for admissions, which also outlined the terms and conditions of the agreement. Even if the court determines that these materials aren't sufficient to bring the terms and conditions into the record, Ms. Baylor's counsel confirmed the terms and conditions of the agreement during oral argument. When asked whether the terms and conditions contained a time limit for tendering the certificate, Ms. Baylor responded that they did not. Ms. Baylor did not assert that the terms and conditions were outside of the record or object to the court's consideration of the terms and conditions. In doing so, Ms. Baylor's counsel induced the trial court to consider materials that were purportedly outside of the record. The court, as you know, the court is in possession of thousands, in many cases, of pages of documents. It can't know exactly what's in the record for every case. It relies on counsel to provide it with guidance. And here, the counsel induced the trial court to believe that these materials were in the record when, according to Ms. Baylor, they weren't. Under the invited error doctrine, Ms. Baylor cannot now claim that the trial court erred by considering materials Ms. Baylor's counsel led the trial court to believe were in the record. For all these reasons, Ms. Baylor's second assignment of error should be overruled. Turning to the third assignment of error, Ms. Baylor states that she was not provided with a reasonable time after the tender of the certificate to pay for the painting. Our position is that Ms. Baylor's performance was due well before Treadway delivered the certificate, because Treadway had no obligation whatsoever to deliver the certificate, and at any time, because Ms. Baylor's challenge to the authenticity of the painting was untimely. Even if the Court of Appeals concludes that Treadway's offer to provide the certificate was a condition precedent, we maintain that Ms. Baylor was provided with a reasonable time to pay for the painting. The auction.
How so?
Well,
After the tender?
right, yeah. The auction occurred in September 2019. I mean, it's not, we believe it's reasonable to expect payment immediately upon performance of the condition precedent, given the amount of time that passed between the auction and the tender, especially since we maintain that that was a gratuitous offer that we made to provide her with the certificate. We had no reason to do that. We were acting to try and resolve this dispute quickly as possible. It's reasonable to expect payment immediately upon delivery of the certificate.
Like the day of delivery?
Yeah,
A year later, the certificate's delivered, and then boom, she has to pay or she's in breach?
Yes,
That's
our position.
reasonable.
We believe that's reasonable. I mean, even if that's not reasonable, that's all that's going to change is the calculation of damages by a couple of days. I mean, it's not going to change the fact that Ms. Baylor is in breach at the end of the day, which is, Treadway's greatest concern. This is essentially a damages issue, not a liability issue. Does the court have any other questions on the third assignment?
Yeah,
Turning to the fourth assignment of error, Ms. Baylor maintains that Treadway's complaint was not ripe when filed because payment was not due until the certificate was delivered in November 2020. Again, our position is that the delivery of the certificate was not a condition precedent. Our offer to provide her with the certificate of authenticity was a settlement negotiation and a gratuitous promise, not an enforceable contract modification. But even if the complaint was not ripe when filed, it indisputably became ripe during the proceedings. There are no cases in Ohio where a court held that a party cannot recover on a claim for breach of contract when the defendant breaches a modified version of that contract after the complaint was filed. There are no such cases because Rule 15 freely allows amendment to the pleadings to conform to the evidence. Rule 15 does not require a party to move to amend the pleadings. In fact, the trial court may sua sponte amend the pleadings based on issues that the parties themselves put at issue. Ms. Baylor put the tender of the certificate at issue. Since she put the tender of the certificate at issue, the trial court correctly concluded that it could resolve the case on that issue. The only case Ms. Baylor cites to support her argument is Kirk versus Kirk. Kirk did not even involve a contract, though. That was a domestic relations matter where the court held that an adjudication of contempt must relate to past conduct, not prospective conduct. This is not an appeal from contempt proceedings. And Kirk certainly did not address the validity of the trial court's application of Rule 15. For all of these reasons, Ms. Baylor's fourth assignment of error should be overruled. Does the court have any further questions?
I don't.
All right. I will ask the court to overrule Ms. Baylor's assignments of error and affirm the judgment of the trial court in full. Thank you.
Thank you. Ms. Crossley-Tate, you have about 4 minutes.
Thank you. It's correct that Kirk versus Kirk is a family law case. Somebody's spouse was just sure that he was not going to reimburse her for something, so she prospectively or preemptively filed her motion for contempt based on his potential future conduct. And the Court of Appeals said the determination of whether a cause is ripe for review is made at the time of the filing, not on subsequent facts. A breach of contract, similarly, must also relate to past conduct and not possible future conduct. So now I will submit Kirk versus Kirk. To my surprise, I expected to find all kinds of law on what I thought was a solid black letter proposition like this. You have to have a justiciable claim when you file the claim. But this is actually the only case in Ohio I was able to identify, or I would have, you know, if I could have found a contract case, I would have cited to a contract case. This is the best I've got. But I think it applies with equal force. So counsel brought up Civil Rule 15. Civil Rule 15 says that when a matter is tried with the consent of both parties, then the pleadings may be amended under Civil Rule 15. There was no trial. This is not a trial. This was a motion for summary judgment. I am aware of no legal authority in the state of Ohio in which Civil Rule 15 can be made to modify matters asserted in pleadings, number one. Number two, James Birch, as trial counsel, simply responding directly to direct questions put to him by the trial court is not the same thing as, number one, trying a matter. It's not being tried at all. Or number two, consenting to the trial of that issue. Now, the pleadings did raise these issues. The pleadings didn't require amendment. The answer filed by Ms. Baylor was among, I think it was the first affirmative defense, if I recall correctly, said a condition precedent had not been met. So there's no question of amending pleadings at all. This is a matter of what's before the court on summary judgment. What was before the court on summary judgment is only that which was asserted in the original motion. The original motion did not assert multiple bases from which a reviewing court could choose or from which the trial court could choose. It asserted a single basis. You got an invoice. You didn't pay the invoice in 30 days. And it is absolutely a defense knocking out that element, that necessary element of that breach of contract action as argued in the motion for summary judgment, to say, I didn't owe you payment. My payment was not due 30 days after the invoice. So Civil Rule 15, I'm going to say, simply has no force or application here. Invited error has no force or application here for reasons I've already gone into. And I don't, let's see, let me get back to another, because I'm super short on time. Let me see if there's another thing I wanted to respond to. Mr. Johnson said there are no materials in the record to dispute whether the certificate was sufficient or timely. Yes, that's what we're saying. There are no materials in the record. We never had an opportunity to get into it. We never had an opportunity to develop our affirmative defense. We didn't have an opportunity to try it. We didn't have an opportunity to present evidence. We didn't have an opportunity to present argument. We're ready to do it, but that was just beyond the scope of the issues as framed in the motion for summary judgment. Are there any further questions?
Not for me. Thank you.
Thank you.
Very much.
Thank you both for your arguments this morning. The case is now submitted, and we will issue a timely decision. Have a good rest of your morning. Okay, the final case today is Spiegel versus Ayani. Mr. Cauchel, would you like to reserve some rebuttal time?
I would, Your Honor, if it please the court, I'd like to reserve 3 minutes.
3 minutes, all right.
Yeah, thank you, ma'am. I would like to talk about the first assignment of error and reserve on the second two, because first, Lodestar, $44,000 in attorney fees, that kind of thing. It's pretty black and white. I don't think it's terribly complicated. The question of finality on the last issue, I'm not sure that it's a final order, the final part. But the first issue, I think, resolves everything here. And it's really interesting because we've got this question of jurisdictional priority versus change of venue. Defendant moved to change venue from Claremont County. They spent their whole motion says venue should change. the Claremont County judge said transfer because of jurisdictional priority. So I think we were kind of arguing at cross purposes in our briefs. My first assignment of errors says is all aimed at jurisdictional priority because that's what the Claremont County judge is talking about. The response is change of venue. Now, the judge never said anything about change in venue except in the title, and I think in the closing paragraph where he orders it to be transferred. His whole gravamen of his argument, or of his decision, is jurisdictional priority, the Triton case.
So you're saying that's the only reason why he transferred? Was for
That's the reason he gave, Your Honor. I mean, clearly, Ms. Spiegel's attorneys messed up when they filed the Claremont County case before they had dismissed the Hamilton County case. I'm not sure that that was in the slightest bit wise,
Right.
but they did. They did what they did.
But didn't the judge also find that Ms. Spiegel was engaged in abject forum shopping by doing this?
Yes, ma'am. But is that an issue about where a venue is proper, or is that an issue of jurisdictional priority? I read that as a jurisdictional priority thing because it lines up with the Triton case and the Gautier case.
Well, venue could be proper in two places.
Yes, ma'am.
And then it sounds like he just thought, well, she's forum shopping and I don't condone this, so I'm kicking it back to Hamilton County. So,
Sure, but if you bring a case after dismissing in one county, if she brought it in Claremont County, say originally,
yeah.
and they moved it to transfer, there's no indication in his decision as to that would have been improper. The contract was formed in Claremont County.
Right.
It was signed in Claremont County. It related, one of the three properties, I think, is a Claremont County property. So if he had addressed it, I think he would have had to say venue is proper in either Claremont or Hamilton County, and maybe both, depending on, one relating to one piece of real property, one relating to the other two pieces of property.
Mm-hmm.
But as I read what he's saying, this is about the impropriety of having been in front of the trial court in Hamilton County and then dismissing for, I guess, because they got a sense that he was going to rule against them, even though he hadn't really made any decisions yet. But, a sense, we all have senses, or whether they're justified or not. I mean, the eviction hadn't been filed, so there was none of that present. So that issue wouldn't be a proper venue issue. So which is it? He's talking about Englehart, but pretty much all of this is about when is the priority, the jurisdictional priority proper, and it sort of tracks the decision of this court in Gautier and of the Triton case about sort of Triton flipped because the facts were opposite. Really, it would have been perfect if he talked about Gautier because that really is a direct addressing of these issues. But he didn't. He said what he said. I read this as being jurisdictional priority for that reason. That's what makes this an interesting issue. That's why I like to talk about it.
Let me ask you, Mr. Crowshore, did anybody challenge, based on jurisdictional priority, Hamilton County's jurisdiction or venue over this particular case?
Not that I've seen, Your Honor. Of course, I wasn't trial counsel, but my review of the record. This is kind of complicated because when the clerk numbered the documents in this case, there are three trial court cases. They started each one with one, so we have to talk about the 981 case, which is the case that arose after the Claremont County judge ordered a transfer. That one seems to have most of the information. They did litigate it up until when Ms. Spiegel's attorneys quit. The trial court allowed them to withdraw. And part of my third issue is sending a notice to an address with a typo in the address where she'd moved out a year previously. Is that actual notice of them wanting to withdraw? They didn't comply with the rules about certified mail, to send the certified mail and then file the receipt before he let them withdraw. So I don't know what they would have done had they stayed in the case. Of course, this is always often the problem. But they did, in fact, contest the effect of the jurisdiction in the Claremont County case, whether the venue was correct there. They opposed the transfer based upon the Rule 3C issue, and that's all we know.
But your real issue is that you're saying the Claremont County judge, instead of transferring, should have dismissed?
I believe that's mandated, I think, by the way the reading is. The Ohio Supreme Court said that you can't transfer except for improper venue. So this is really an interesting logic issue, because they asked to transfer for venue. He said jurisdictional priority, and then he transferred. If it is jurisdictional priority, then he would have had to dismiss, because he's not allowed to transfer pursuant to the Ohio Supreme Court decision. Mm-hmm. Does that mean that he was subconsciously finding a venue? I don't think we can get into his brain that much.
But would you agree that if venue is proper in both jurisdictions, I mean, you agree that it is, right? It's proper.
Yes,
in
I
both
believe the
jurisdictions.
facts are clear that it would
Okay.
have been proper in either.
And the judge did make a finding that your client was forum shopping, right?
Yes, ma'am, he did.
Okay.
He did.
So in that instance, he couldn't transfer back to Hamilton County?
I don't think so. I think he has to dismiss, because the Triton, or the,
Well, let me ask you this. Had he dismissed, wouldn't your client have just refiled in Hamilton County?
I'm
Does it
not
matter?
sure that
Does it matter at
wiser
all?
heads might not have prevailed, Your Honor.
Or just said, okay, this is over, we're not going any further on it?
I think if I had spoken with her after that dismissal, I might have discouraged refiling in Hamilton County.
But you weren't the lawyer.
Correct.
Okay.
Correct.
So she didn't have your counsel.
That's correct, Your Honor. So, but I don't know. And that sort of goes into the second issue for this $44,000 in fees against her. You know, she would not have known about any of these things. I mean, yes, she's responsible for the behavior of her lawyers, but generally when we see frivolous conduct sanctions, in my experience, it's against both the attorney and the client. It's limited by the rule. There's a lodestar determined. I mean, that's not rocket science. We go in here, we talk about what the value is. We put an expert on the stand. It says, my opinion is the value of the counsel is X amount times the number of hours. You don't just throw out a $44,000 decision against the client. So,
But you're not, just to be clear, on appeal, you're not challenging the court's frivolous conduct finding, are you?
the misconduct filing?
The finding of frivolous conduct, you're not challenging, you're challenging the
Correct.
amount of the fees.
Correct.
Okay,
Yes.
so that's the only issue that we're dealing with.
Right,
Okay.
and that's my second issue, is the misconduct of the attorney truly attributable to her? Is a $44,000, $266 judgment against her appropriate, where much of it is, some of it relates to the eviction that hadn't been part of the earlier case? I'm sorry, I'm changing what I said and not going into the second assignment of error, but.
But that's the thing. I mean, you're challenging the lodestar, and it seems like they had their, are you challenging that the hourly rate is unreasonable?
I am. Your
Okay.
hourly rate plus hours reasonably expended.
Okay.
Because it includes things that were past the transfer. And as I
Okay.
read the transfer rule.
And that is true.
It's only up through that time of transfer.
Right, okay, so, and there were numerous entries that were billed that were beyond the period that the court initially said it was focusing on?
Yes, ma'am.
Okay,
Yes, ma'am.
I mean, my understanding was the court here in Hamilton County cut Mr. Musicamp's fees by about $5,000.
Yes, sir.
What was requested. So, but are you asking us to go line by line and, in essence, second guess what the court determined?
Oh, no, Your Honor, because I don't think the court followed the correct procedure at all. I would ask that the court, on that issue, would remand it back to the judge to go over it and do what he should have done the first time, which is determine the lodestar, figure out the hours that were reasonably expended, multiply it, and get a judgment that way.
well, he did, I mean, I thought he did figure out the hours that were reasonably expended. You're just saying that there were hours beyond, that he was wrong in that, right? I mean, he reduced it by 5,000. He did include hours that were beyond the transfer time,
Clearly,
right?
clearly.
But-
All we know is his page 4 of his decision on the attorney fee order. Based on the evidence and argument of counsel, the court finds that Mr. Ianni's reasonable attorney fees and costs are $44,226.68. That's it. So did he reduce them by $5,000 because he had a sense that maybe they overdid? Or did he do it because he did the math? I don't think so, because the number seems too round. If I was an IRS agent doing the audit, I would say that round number sets off an alarm bell. He just reduced it. Well, I don't know why, but I would suggest, or I would ask the court to remand it. If you don't find that the transfer was wrong, that you remand it at least for the question of the attorney fees. On the third assignment of error, I don't think it's actually a final order. He said it was a final order. So I argued it.
But you are at your time if you want to reserve some rebuttal.
Yes, thank you very much.
Good morning, Your Honors.
Good morning.
George Hughescamp on behalf of the appellee, Peter Ianni. May it please the court, before I get into the assignments of error, I know there's a long, complicated, frankly, procedural history here. Would it help give a refresher to the court? I know we briefed it and it's in the briefs, but if it would help, I'm happy to go through a very brief timeline. But if not, I can get right into the assignments of error.
I think we
We read everything.
figured it out.
Fair enough,
It
fair
took a
enough.
little time,
Yeah,
but we
Yeah,
figured
right.
it out.
It's confusing for me. I was kind of hoping you'd say no, frankly. Let's start with the first assignment of error here. Whether the Claremont County Trial Court erred in ordering the transfer of case 2021 CVH 929 from Claremont County back to Hamilton County.
What were his ground? What did he say was the reason?
Judge Ferentz?
Yeah.
I would argue that he did it on both. We only moved on motion to transfer venue. The jurisdictional priority rule, frankly, was not briefed whatsoever in our motion.
Did he say jurisdictional priority?
He cites the jurisdictional priority rule. He does mention the jurisdictional priority rule in the top half of his order. And then at the bottom half of his order, he gets into kind of the abject forum shopping and why this venue, this county in Claremont County is not proper. And I think it's entirely proper for the court to say jurisdictional priority rule, and this is the improper venue, and I'm going to transfer it back to Hamilton County where this case belongs. Because let's not forget that Ms. Spiegel initiated this case the first time in Hamilton County, participated in a TRO hearing, evidentiary hearing. Orders were issued. There was a case management conference before Judge Triggs where there was another hearing to be set. Everybody thought, frankly, this case is going to continue to move forward in Hamilton County. And we were then blindsided when they dismissed and refiled in Claremont County. So we followed the proper procedures and filed a motion to have it transferred back to Hamilton County, and that's what happened. But I guess really, from my perspective, it doesn't really matter, frankly, whether it was a motion to transfer venue and it was transferred, or whether it was dismissed and then our case that was filed in Hamilton County in the meantime got consolidated. It doesn't really matter because, as Mr. Crushore just admitted, they aren't disputing the frivolous conduct sanctions. So even if it's jurisdictional priority rule, it is Judge Triggs still found in Hamilton County It is frivolous conduct to dismiss your case and then refile in an improper forum in violation of the jurisdictional priority rule. Even if that JPR rule applies, they've still forum shopped, they still moved to avoid an adverse ruling from Judge Triggs, which was surely coming down the pipe, and we eventually got through Judge Ruhlman, which was not appealed. So I don't, it's a
But
distinction.
was it really improper, though? What was Claremont County, I mean, there was a property at issue in the contract that was in Claremont County, right?
There was.
So would it, I mean, could that be a grounds for Claremont County being proper?
I think if, I guess if they would have followed the
Initially.
jurisdiction priority rule, yeah, let's assume that happened. We briefed that and we said no. We said a case law that said tangential connections to the county are not enough. And the entire thrust of this case was Hamilton County. The parties were both living in Hamilton County. The breach occurred in Hamilton County, and that's actually the only thing you look at when you're deciding venue on a breach of contract. It's not where the contract was formed, it's where the breach occurred. Both parties were residing in Hamilton County. The breach occurred in Hamilton County. The eviction proceeding had to proceed in Hamilton County. Hamilton County was the only court that could hear the eviction proceeding when Ms. Spiegel would not vacate the property that she didn't have a lease for and she wasn't on the deed.
That's your client's lawsuit.
Correct, yes, ma'am.
But for her lawsuit, she could have picked, I mean, you're disputing that the pewter property would give venue in Claremont County?
Correct. I don't think that's enough.
It's
given
not enough.
all the other weight that was in Hamilton County and the work that the Hamilton County judges had already done. I do not think the Claremont County property alone was going to be enough to keep venue in Claremont
You're
County.
talking about it had already done, I'm talking about if she had initiated it in Claremont County.
I still would have moved to transfer venue back to Hamilton County, correct? I do
Okay.
not think that alone is enough.
Okay.
And again, though, and we can kind of go back and forth this, but I generally don't think it matters because they've already conceded the frivolous conduct under 2351. And Mr. Crushore is really arguing that jurisdictional priority rule, Claremont County never had the case to begin with. So, I mean, we're kind of like, the hypotheticals under the facts of this case, I don't think it really matters. It came back to Hamilton County. And then, Your Honor, Judge Winkler touched on my first argument I'd like to make. I went a little out of order is Rule 12H is clear on its face. You have to make a motion or you have to put it in a responsive pleading. And under the facts of this case, Ms. Spiegel did neither. And the rules say what the rules say, and the civil rules are there for a reason. And they had an opportunity when they answered our counterclaim to put that as an affirmative defense under Rule 12, and they did not. And they waived it by not doing so and then completely participated in Hamilton County. And I understand that they opposed fees in Hamilton County. I understand they opposed the transfer of venue in Claremont County. But Rule 12H does not say, but we also make an exception for filing an opposition for a motion to transfer venue. 12H says on its face, and it should be interpreted as written, filing a motion or in a responsive pleading, and they did not do that. So I'd say on that basis alone, the first assignment error has been waived, and we don't really need to get to the merits. But if we do, Your Honor, to answer your questions, I do believe that the Claremont County was the improper venue. And again, I would reiterate, I don't think it matters because Ms. Spiegel was still sanctioned for frivolous conduct, and nobody has challenged that. Which kind of actually dovetails well on the issue for fees. There was some argument that the appellant was sanctioned for conduct that occurred after the transfer. That rule only applies under Rule 3. Frivolous conduct does not have a stop and start time like Rule 3 does. Rule 3 says you can get fees up to the time of transfer. Again, Judge Triggs' order said, I'm sanctioning you for frivolous conduct under 23-2351, and you're also getting your fees under Rule 3 as well. But even if we set that aside, 23-2351 allows for fees on frivolous conduct. We filed motions for sanctions in Hamilton County, which obviously occurred after the transfer because it had to, because we couldn't file the motion until it was transferred. We had a reply to that brief. We had to have a full-blown evidentiary hearing where I was subject to cross-examination on the reasonableness of my fees. We then had, by Ms. Spiegel's counsel's request, we actually had post-trial or post-evidentiary hearing briefing as well. So yes, the number added up very quickly, and there is no stop on 23-2351 in terms of the clock's going to stop running.
So this is all of these additional hours of work were directly the result of this frivolous transfer?
Yes, ma'am.
Is the argument?
Yes, ma'am. And
Okay.
I would say Mr. Crushore identified, I think, 5 time entries in his brief that related to the Judge Ruhlman case, which was the eviction case. I think that amount totaled about $1,000. I did the math. It was like 1,000 and change. So even if that's true, let's, again, I guess, assume it's true, Judge Triggs deducted $5,000 from my ultimate fee request. So I was,
But what was the reason for that?
I'm assuming in his discretion, he decided that I'm not sure, there was a lengthy cross-examination of myself and argument on the briefing where the arguments Mr. Crushore is making now on why the fees were excessive or too much or should be lowered were made, and Judge Triggs took it under advisement and then issued his ultimate order lowering it by $5,000. So I would say even if the $1,000 was over, he lowered it by actually more than $1,000. So Ms. Spiegel actually got exactly what she was asking from Judge Triggs. I would say that on the issue of fees as well, there was some argument in the appellate's brief that there wasn't a lodestar conducted. I think that's Exhibit 1 to the brief that we filed here in this court that we presented to the trial court, which is a chart literally laying out the lodestar calculation. It lays out my hourly rates, it lays out Mr. Sandlin's hourly rates, it laid out the hourly rates of a lower associate we used, and then calculating the hours we spent in the case, which comes to a total number. I don't think it's appropriate for this court or to force Judge Triggs to go line by line by line by line of every single time entry. And I don't think the law requires that for him to do that sort of calculation. He sat there and heard evidence. He actually asked me questions as well while I was sworn in on the witness stand. So again, he did a calculation, he heard evidence, he took evidence. There was a massive amount of briefing on this issue, and I don't think there's anything in the record that would qualify or meet the standard for him having abused his discretion in awarding fees. On the last issue, the third assignment of error, Judge Triggs' order that it actually did 2 things. And I just want to make sure we're clear on this. He granted motion for judgment on the pleadings as to part of the claims that were in the handwritten contract. That issue has not been appealed. So judgment on the pleadings was ordered, and that issue is not up on appeal. I did not see that in the appellate's brief. The only thing that's been appealed on the third assignment of error was the dismissal with prejudice of Ms. Spiegel's claims. And really the crux of her argument is that she didn't have notice when Judge Triggs ordered her to show cause to appear after she...
After her lawyer withdrew?
Right, her lawyer withdrew because she stopped communicating with her lawyer, and then she didn't appear for the motion withdrawal, and then she needed to appear for the motion to show cause. And I guess I'm not here to argue one way or the other whether her counsel complied with providing Ms. Spiegel notice or not, but what I would say, it's a case she initiated. She's a party. She was in Hamilton County. The correct address is on the clerk's website, even though I do recognize there was a typo on Judge Triggs' order. I don't believe that the clerk of courts goes on what's on the order. They're going to use the address that's actually filed with the clerk of courts.
So that's in the record. It was that, so her correct address is with the clerk of courts. There was apparently a typo on like a docket sheet or something.
Yes, Your Honor. There was a
Okay.
typo on the actual order, on Judge Triggs' order. It said serve on counsel, and I think Ms. Spiegel at 888. There was an extra number in there on Fawn Meadow, but on the clerk of court's website, and we put that in our brief, a screenshot. It actually had her
Okay.
address. And I also understand that she had been
But
removed.
the court had removed her from that
She's been
address.
removed from Fawn Meadow, understandable, but I mean, again, at some point, Ms. Spiegel's in a lawsuit. She's got a duty to update her address. I don't know if she had mail forwarding, but again, even though she says she had no notice, there's nothing in the trial court record that said why she wasn't receiving notice, right? She could have filed a motion to set aside the judgment under Rule 60B. She could ask for a motion for reconsideration and filed an affidavit and said, Judge Triggs, here's why I didn't get notice. What we're dealing with now are a lot of hypotheticals on why she may or may not have received notice. And the other irony in all of this is she must have been receiving notice because she's here today appealing the orders that were emailed to her. And I guess I would ask is how did she know to appeal those orders if she wasn't getting notice? I assume she wasn't just
Could have gone and checked eventually.
I'm sorry?
She could have checked the docket eventually.
That's exactly my point, Your Honor. She should
Yeah.
have been checking the docket. It's her case. She is a party. She has a responsibility. I would say she has a duty. She cannot come and go as she pleases in and out of courts. And Judge Triggs was obviously not happy with her. And obviously she had engaged in abject form shopping. And
That's a really harsh penalty. And I think we know that the court had to know that that Fawn Meadow address she was evicted from. So even if it's correct or incorrect, the court knew she wasn't living there anymore. So I think we have to get to the point of, okay, what was her responsibility in all of this? And did she need to be actively checking the docket, right? And is that enough to say, yeah, you needed to do that and you're going to suffer this harsh penalty of having all of your claims dismissed?
I completely agree with you. It is a harsh penalty. I agree with that 100%. I would say she had a duty to appear in court when Judge Triggs told her you got to appear in court. And on top of that, she had a duty to maintain her address and check the docket. I mean, I understand that it's a harsh penalty. I completely
Yeah.
agree. If there's any questions from the court, I'm happy to take those. Otherwise, I think I've addressed all the assignments of error.
I think
I don't
that's,
have any. Thank you.
Thank you, Your
oh,
Honor.
thank you. Mr. Kosher. You have 3 minutes.
Thank you, Your Honor. I guess the word that keeps coming into my brain as I look at all of these things is speculation. We speculate as to what the Claremont County judge meant in his order. We're speculating on how Ms. Spiegel knew about the entry and the order. We're speculating on what the judge did in relation to the attorney fees. I don't think any of those things are proper. I think we have to hold the system to require some clarity. Some clarity, for example, on the motion for judgment on the pleadings, the judge had granted only in relation to 2 of the causes of action. We're speculating as to what he would have done with the others on a motion for judgment on the pleadings. We're speculating just everywhere. The question of the tangentiality, since it's not addressed in the Claremont County judge's order, we're speculating as to what he would have, could have, or should have done on that. And I don't think that is how, I'm trying to envision myself explaining to my client how this got here. And I have not been able to do so because all I can do is speculate. Did he do it because of this? Did he do it because of that? Did he say abject forum shopping in relation to Rule 3, or did he say abject forum shopping in relation to procedural, the jurisdictional priority? I don't know, and I don't think the court can know, and I don't know that he knew. I don't think that the Hamilton County judge went through and said, oh, I accept the lodestar of the hourly rate, especially given those dollar amounts when I've pulled some other cases on lodestars and the amounts given were not pushing $500. Did he just accept that and he just knocked it down a little bit? I mean, it just seems to me totally improper to engage in that speculation. And that's got to be the word that keeps running through my brain in this from beginning to end is we're just speculating as to what happened, and I don't think that's right. I think the court should send it back to the Claremont County judge, maybe not with instructions to dismiss, but at least to tell us what he's doing and why. And then if we end up back here in a year or 18 months, then we can talk about something that's not speculative. Thank you, Your Honor.
Let me just ask you one follow-up question. This is based on an answer you gave me about the advice you would have given to Ms. Spiegel. And I know that in your third assignment of error, you talk about the claims that were dismissed. Are you abandoning that, or do you still want us to consider that?
Oh, no, absolutely. If needed,
Right.
if we're not going to send it back to Claremont County, then I would like the third assignment of error to be considered because I don't know why, even why her claims were dismissed, other than she didn't show up at a show cause hearing, but she hadn't been notified of what she needed to do to show cause. Her lawyer
You
quit.
answered my question. I didn't,
It's
that
all
was
right.
based on one of your earlier answers. Okay.
I don't mean to
No,
go
that's
on
okay.
and on.
All right.
Thank you,
She's
sir.
going to push the button right now.
Thank you.
Thank
very
you.
much.
Thank you both for your arguments this morning. The case is submitted, and we will issue a timely decision. Have a good morning.
These damn wires under there. My feet we're getting